They called her a Trump puppet, until she walked into the Supreme Court and dropped a legal bomb that could rewrite the Constitution forever. When the Supreme Court docket listed Coalition of States versus Department of Homeland Security, few paid attention. It sounded procedural. Routine. A coalition of 19 states was suing the federal government over immigration enforcement rules they claimed imposed on local autonomy. But for Washington insiders, this was déjà vu, a familiar fight over jurisdiction, buried in bureaucracy. No one expected a national moment. At the center of the case stood Pam Bondi, now U.S. Attorney General, a role many said she didn't earn. A former state prosecutor, cable news figure, and Trump's impeachment defense attorney, Bondi was widely dismissed as more political than legal. The New York Times ran a preview piece headline, "Can a partisan figure defend state sovereignty?" Even conservative outlets had doubts, citing her lack of federal appellate experience. And yet there she was, standing alone at the lectern in the marble echo of the Supreme Court chamber. The justices were prepared to make an example of her. Chief Justice Roberts opened with an immediate challenge, asking how her state's sovereignty argument didn't collapse under Garcia v. Brookhaven, a precedent limiting the 10th Amendment. Justice Kagan followed sharply, noting that immigration fell under federal supremacy. The question wasn't subtle. Was Bondi just replaying old states' rights debates under a new headline? Inside the chamber, it looked like a slow, public unraveling. Reporters' pens hovered, prepared to sketch the fall. But Bondi didn't blink. She began carefully, not defensive, but deliberate. "Chief Justice, Garcia is labor-related and doesn't nullify anti-commandeering protections," she said. "We're not challenging supremacy. We're demanding constitutional limits." Then came her first pivot, Murphy v. NCAA. She cited it from memory, linking sports betting regulation to immigration enforcement with surgical precision. Justice Thomas shifted in his seat. Gorsuch looked up. The court was still skeptical, but no longer dismissive. Outside the chamber, a small crowd of state officials and aides watched the live stream in the overflow room. They weren't expecting a performance. What they got was an opening act that held the court's full attention. The moment didn't arrive yet. But something had shifted. Even skeptics began to wonder, was she just repeating old arguments, or setting the stage for something new? The second hour of argument blurred the courtroom into quiet intensity. What had begun as a procedural challenge was now clearly different. Bondi, still composed, moved past citations and into structure. The justices, one by one, tested her endurance. Justice Kagan pushed again. "Counselor Bondi, Prince versus United States was about background checks, not immigration. Isn't your analogy stretched?" Bondi didn't flinch. "Justice Kagan, Prince affirms that states cannot be compelled to enforce federal mandates. The domain may differ, but the principle endures." Her tone was calm, not defiant, not rehearsed. And that mattered. Legal observers in the gallery began scribbling notes. Some shifted forward in their seats. Roberts, who had opened with open skepticism, now leaned slightly, no longer aiming to break her down, but to test the weight of her logic. Justice Alito tapped a finger on the bench. "If funding is provided, and states are fully reimbursed, is it still coercion?" Bondi: "Yes. Because coercion isn't erased by compensation. If a threat underlies the funding, it's not a choice, it's leverage." She cited NFIB v. Sebelius, the Medicaid expansion case, where the court had struck down a similar funding threat. This was the pivot. Bondi wasn't just referencing case law, she was layering it. One argument atop another, each reinforcing the last. Then came the question that changed the tone of the room completely. Chief Justice Roberts sat back, pen resting. "Counselor, if the court accepts your view, how should we distinguish cooperation from coercion in future cases?" The question wasn't adversarial. It was architectural. Bondi paused briefly. Then, for the first time that morning, she leaned forward. "Mr. Chief Justice, I propose a three-part framework. First, federal policy must have a constitutional basis. Second, it must not compel states to execute it. Third, any funding must incentivize, not penalize." She didn't call it a doctrine. Not yet. But the murmurs from the clerks' row suggested they understood what was happening. A legal test, original, usable, and balanced, had just been spoken into existence. Reporters exchanged glances. A Washington Post journalist closed one notebook and opened another. "We're going to need a new lead," she whispered. Inside the chamber, a subtle shift occurred. The energy didn't spike. It tightened. Justices scribbled more. Clerks typed faster. Law students in the gallery looked up, not down. No ruling had been issued. No headline declared. But everyone in that room began to realize Pam Bondi had brought something new. Not noise. Not politics. A framework. And no one knew yet how far it would reach. By the time Bondi named it, the Bondi test, it was already circulating on legal Twitter. A Georgetown professor tweeted, "Bondi proposes a 3-part test. Could become the new standard." It wasn't flattery. It was recognition. Bondi had crossed the threshold few attorneys ever reach. She'd reframed the legal conversation while standing at the lectern. Inside the court, reactions were measured but unmistakable. Justice Gorsuch adjusted his glasses with a rare smile. Kavanaugh scribbled furiously, flipping a legal pad mid-note. Even Justice Kagan, the court's sharpest skeptic, narrowed her gaze, but did not interrupt. Roberts, expression flat but eyes sharp, leaned in. "Counselor, the Bondi test presumes clear coercion. But what if states have differing interpretations of that line? What if their interests conflict?" Bondi nodded, her voice steady. "Mr. Chief Justice, the court already balances such variance in rulings like Shelby County versus Holder. The Bondi test offers structure, not rigidity. It protects autonomy without enabling obstruction." The courtroom held still. That word, structure, was not lost on them. At the Solicitor General's table, silence. The federal government's counsel, once poised for an easy victory, now gripped his notes, his outline increasingly useless. Every citation Bondi offered wasn't just precise, it was strategic. She pulled from Murphy v. NCAA, New York versus United States, even Madison's Federalist 39. All roads pointed to one message: states were partners in federalism, not instruments. And it wasn't only the justices who were watching. Outside the court, legal commentators flooded cable networks. Some praised her for returning constitutional law to first principles. Others warned that if adopted, the Bondi test could unravel decades of centralized policy. The split was ideological, but the fascination was bipartisan. People didn't agree on her. But no one was ignoring her. Then, the most unexpected reaction came from within the court. Justice Clarence Thomas, usually silent during arguments, spoke. "Counselor," he said, his tone even, "you argue the states cannot be compelled. But can they be shielded from all consequence when they resist?" Bondi turned to face him. "Justice Thomas, consequence is part of federalism. Coercion is not. The Constitution permits persuasion, not conscription." The room did not applaud. It never does. But the pause afterward felt like resonance, not silence. The Solicitor General did not rebut. No one knew how the court would rule. But it no longer mattered whether Pam Bondi belonged in that room. She had changed the room. By the afternoon, the court's marble columns outside were crowded with press vans, security barriers, and a tide of speculation. Inside, the justices had retired to their chambers, but the case had taken on a life of its own. Bondi's closing argument was brief, no theatrics, no flourish. She simply repeated her test, then stepped back. It was not a performance. It was an offering. The Solicitor General declined a rebuttal. That decision, deliberate or stunned, only added to the sense that the ground had shifted. While the justices conferred behind closed doors, the country reacted in real time. On cable news, conservative anchors hailed Bondi's clarity. "She gave them a map," one said. Progressive commentators were less certain. "She's opened a door we might not want to walk through," warned a former Obama White House counsel. "States could use this to reject climate regulations, civil rights enforcement, anything they dislike." But that was the point. The Bondi test wasn't a weapon. It was a threshold. And thresholds always raise the same question: who gets to walk through? By dusk, the first editorial appeared. The Wall Street Journal ran a headline: "Pam Bondi just reshaped federalism." The New York Times struck a different tone: "Trump's former lawyer may have just hobbled the federal government." Both papers used the same photo: Bondi walking out of the court alone, head up, expression unreadable. At the Department of Homeland Security, emergency briefings began. If the Bondi test was adopted, every state with pending objections to federal immigration enforcement could begin noncompliance by citing constitutional autonomy. DHS lawyers drafted memos. Governors in 19 states met privately. What had started as a narrow dispute was now a blueprint. And Bondi herself? She stayed silent. She issued no press release, gave no interviews. When a reporter caught her exiting a government car, she declined comment. "The court will speak," she said simply. Inside the Supreme Court building, Justice Gorsuch drafted. The majority was forming, not unanimous, but strong. Roberts, once skeptical, now careful. Barrett leaned in favor. Thomas was immovable. Kavanaugh intrigued. Kagan and Sotomayor remained cautious but engaged. Alito, quietly enthusiastic. At 8:13 p.m., a legal blog posted a leaked draft title, Opinion of the Court, Bondi v. DHS Framework Adopted. There was no ruling yet. But the shape of it was visible. And it no longer belonged to Bondi alone. The official ruling came 10 days later. Roberts read the decision aloud in a packed courtroom. His voice was composed, but each word carried weight. By a vote of 6-3, the court holds that the Department of Homeland Security's regulations violate the anti-commandeering principle. We adopt the Bondi test as a constitutional standard. He didn't embellish. He didn't need to. Justice Gorsuch wrote the majority opinion. He praised the Bondi test as an elegant framework that upholds federal integrity while respecting state autonomy. He cited New York v. United States, NFIB v. Sebelius, and Murphy v. NCA, echoing Bondi's citations almost word for word. Roberts wrote a short concurring opinion, brief but pointed. Counselor Bondi's contribution reframes the practical boundary between cooperation and coercion. The court acknowledges the strength of her framework. Justice Barrett, too, concurred. The Bondi test avoids vague balancing. It gives structure where structure has long been absent. The dissent, written by Justice Kagan, warned of fragmentation. This ruling grants states a selective veto over national policy. It risks undermining the uniformity our Constitution promises. Outside, the moment hit with force. On the steps of the court, protesters and supporters clashed instantly. One group held signs, "States' rights are human rights." Another chanted, "Immigration is federal law." Microphones swiveled from one to the next. No one stood still. At the White House, the press secretary offered a neutral statement, but reporters noticed the tension. "The president respects the court's authority," she said, "and we will review the ruling's implications." Behind closed doors, DHS lawyers were already triaging. Funding directives, compliance agreements, enforcement schedules, all now subject to the Bondi test. In state houses across the country, governors acted fast. Texas, Elk Valley, and Florida each announced their intention to reassert control over immigration enforcement. Democratic governors in Hawthorne and California condemned the ruling as a threat to federal unity. A national legal map was being redrawn, one decision at a time. On campuses, the impact was immediate. Yale Law School added a new seminar, The Bondi Test and Modern Federalism. Harvard invited Bondi to speak. Westmore Academy released a faculty statement calling her framework the most consequential legal articulation of state power in a generation. Still, public opinion remained fractured. Social media lit up, as it always did, but the responses split down familiar lines. "Pam Bondi saved the Constitution," wrote one user. "She just dismantled immigration law," countered another. Through it all, Bondi made no victory tour. She appeared only once, on a panel at the Federalist Society. Her comment was brief. "Federal power must be strong, but it must also be bound. That's what the framers wrote. That's all we asked the court to remember." She didn't mention her name. But everyone else did. In the weeks after the ruling, the Bondi test moved faster than anyone expected. Federal judges in district courts from Silver Mesa to Ravenbrook began citing it. One opinion, striking down an EPA compliance order, quoted Bondi's exact language. "Incentives are not constitutional if silence carries a threat." Another halted enforcement of a federal education grant until, the judge wrote, "the coercion test described in Bondi is applied." Suddenly, everything was subject to the test. Environmental regulations, housing compliance standards, pandemic funding clawbacks. State attorneys general across the country, especially in red states, filed motions invoking the Bondi test to pause or block federal rules. Even critics were using it, begrudgingly. A liberal law professor wrote, "This test is flawed, but it's clear. That alone makes it dangerous." Congress, meanwhile, scrambled. Senate hearings convened. Members from both parties expressed unease, though for different reasons. Some accused the court of judicial overreach. Others warned the ruling created a framework states would exploit. A leaked memo from the Department of Justice revealed internal concern. The Bondi test, though narrowly defined, could erode cooperative federalism if interpreted expansively by lower courts. But the damage, or impact, was already done. The American Bar Association scheduled a symposium. A leading journal ran a cover titled Pam Bondi and the Return of the 10th Amendment. Conservative legal groups circulated model briefs built on the Bondi framework. Progressive legal clinics published toolkits on how to resist the test's misuse. And yet Bondi herself remained silent. Reporters tracked her movements, mostly between Washington and Ashton Falls. Rumors swirled. She'd be offered a seat on the D.C. Circuit, or maybe a nomination for the Supreme Court if a Republican took the White House. One profile claimed she was being courted by 3 law schools to teach full-time. Another said she was drafting a book. None of it was confirmed. She gave no interviews. She posted nothing. Instead, one morning, a short video appeared online. Not from Bondi, but from a former law clerk who'd worked alongside her early in her career. It showed Bondi standing at a podium in a small classroom, speaking to a group of first-year law students. Her voice was calm. "Don't build arguments to be liked," she said. "Build them to last. The law doesn't remember applause. It remembers what worked." That clip went viral. No music. No editing. Just a phone camera and a plain sentence. The top comment read, "She changed the Constitution without shouting once." And then, quietly, the next debate began. Not about Bondi, but about how to use her test. The Supreme Court's ruling in Coalition of States v. DHS faded from headlines faster than it should have. News cycles moved on. But inside legal circles, the Bondi test settled in like bedrock. Law students began referencing it without context. Judges cited it routinely, sometimes narrowly, sometimes boldly. A decision out of the Fifth Circuit used it to halt a Department of Education funding condition, prompting a cautious op-ed in The Atlantic. The Bondi test, subtle shift, structural shock. Meanwhile, state legislatures began quietly inserting language into their bills, coercion review required under Bondi, as if it had always existed. But something else was happening too. Civil rights groups, at first alarmed, realized they could use the Bondi test against federal policies they long opposed. One filed suit arguing a federal housing requirement discriminated against local zoning autonomy. Another used it to block a federal directive tied to surveillance funding. The test, originally seen as a tool for conservative defiance, was now being used by both sides of the spectrum. Pam Bondi had built something bipartisan, not in intention, but in function. And still, she remained quiet. Until a call came. It was not from a news outlet, law firm, or political committee. It came from a public university in a rural part of the North Crest region. They were hosting a panel on state sovereignty. The organizer, a young professor, invited her without expectation. He never imagined she'd accept. But she did. The event was modest. 100 students, maybe fewer. A local reporter in the back with a recorder. Bondi wore a simple blazer. No cameras. No statements. When asked why she came, she said only, "If the test belongs to the law now, I should be willing to answer for it." One student, in a soft voice, asked what she thought the test's legacy would be. Bondi paused, then answered plainly, "That depends on who uses it next." No applause followed. Just the weight of the answer. Weeks later, a lower court in New Jersey applied the Bondi test to block a federal mandate on vaccine distribution. That same week, a California judge used it to defend state climate policy from a federal rollback. Different cases. Opposite politics. Same framework. And suddenly, what Bondi had built was no longer just a rule. It was a mirror. The legal world had stopped asking whether she was right. Now, they were asking how far the test could go. And whether it was already too late to pull it back.